that I gave to the Georgia Public Service Commission on December the 18th at the invitation of then Chairman Tim Eccles, who is also a Madison Forum member. And he told me, he said, he gave me free range. He said, you can speak on anything you wish to speak on. So I thought, well, let me research John Roberts' opinion. And I read his 190 plus pages. And from that, this is the speech I gave to the Georgia PSC on December the 18th. My name is Michael Opitz. I'm president of the Madison Forum, a civic, nonpartisan organization focused on good government with a constitutional foundation. And in this year's Georgia primary election, I was a candidate for Congress in the 11th District. I appreciate the opportunity to appear before the PSC this morning. Very few people have read the Supreme Court ruling on the Affordable Health Care Act, otherwise known as Obamacare, written by Chief Justice John Roberts. His justification and writing supporting his rulings goes far beyond health care and taxation. And this bears great notation because it restates and underscores federalism and the responsibilities of the states to exercise their rights under the 9th and 10th Amendments. Justice Roberts certainly is no right-wing radical, but he does support fundamentals of the Constitution from his perspective, and his will is now the law of the land. So let's understand the logic of his thinking that supports that law. And I quote here from his ruling. I will let you know when I stop quoting Justice Roberts' ruling. And our cases have recognized limits on Congress's power under the spending clause to secure state compliance with federal objectives. We have repeatedly characterized spending clause legislation as much in the nature of a contract. Legitimacy of Congress's exercise of the spending power thus rests on whether the state voluntarily and knowingly accepts the terms of the contract. Respecting this limitation is critical to ensuring spending clause legislation does not undermine the states as independent sovereigns in our federal system. That system rests on what might first seem a counterintuitive insight, and that freedom is enhanced by the creation of two governments, not one. Otherwise, the two-government system established by the framers would give way to a system that vests powers in one central government, and individual liberty would suffer. That insight has led this court to strike down federal legislation that commandeers a state's legislative or administrative apparatus for federal purposes. He said, see Prince 521 at 933, striking down federal legislation compelling state law enforcement officers to perform federally mandated background checks on handgun purchasers, invalidating provisions of an act that would compel a state either to take title to nuclear waste or enact particular state waste regulations. It has also led us to scrutinize spending clause legislation to ensure that Congress is not using financial inducements to exert a power akin to undue influence. Congress may use its spending power to create incentives for states to act in accordance with federal policies, but when pressure turns into compulsion, that legislation runs contrary to our system of federalism. The Constitution simply does not give Congress the authority to require the states to regulate. End of quotation from his ruling. I went on to say to the full body of the PSC panel, a PSC commissioner spoke several months ago, and this commissioner was sitting on the panel when I said this. Spoke several months ago at a Tea Party meeting where he explained that because of EPA mandates, the cost of energy derived from coal-burning plants for Georgians would increase. However, the PSC was challenging that ruling in federal court. I asked the question, Where in the Constitution is it stated that a federal government agency has the power to direct a state to implement its directive? As I recall, the commissioner had no answer. And he was sitting there and he still had no answer. He did not say anything. What if some other federal agency issued the same guidelines as the EPA? By what authority do they have over the states? According to Chief Justice John Roberts, they have no authority other than that which the states wishes to give them as a full partner in compliance. This leads us to another point. Why would a state take this issue before a federal court, which may take years before reaching the Supreme Court for a final decision? When the states are directed by the U.S. Constitution, who has their pocket Constitution with them this morning? Read along with me. Directed by the U.S. Constitution, Article 3, Section 2, Paragraph 2. In all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. This provision of the Constitution makes us question why the states, including Georgia, began their lengthy federal court cases with lower-level courts when the Constitution clearly states that the Supreme Court shall have original jurisdiction. It makes us wonder if the continuous federal appeals reap financial benefits for years as private law firms and attorneys represent the states in the appeals process. It appears that Georgia does not fully understand its constitutional powers and role in addition to those under the 9th and 10th Amendments. Why spend the time and the money going through a lower federal court appeals process when it has the authority to go directly to the Supreme Court? Surely this appeals process is not just a jobs program for attorneys and wasteful spending, because the Supreme Court has already ruled in Georgia's favor and the states are not the vassals of the federal government. To repeat Chief Justice John Roberts, quote, "Otherwise the two-government system established by the framers would give way to a system that vests power in one central government." I have already mentioned Justice Roberts' reference to nuclear power regulations nullified by previous rulings. I strongly recommend that this esteemed body review all federal regulations that affect PSC compliance, related costs, as well as good practices that have a negative impact on Georgia and its service providers. A new day is before us, and that day is not a footnote in constitutional legal philosophy, and it is now reaffirmed by a most current Supreme Court ruling. I sincerely hope the PSC and other state government agencies strongly defend Georgia's constitutional status as an independent sovereign as we seek to solve our own problems. Thank you very much.